and we're going to move on to looking at the bills this session that dealt with concealed weapons and self-defense.
John, we've worked the legislature for several sessions now, and firearms and pit bulls are an area that are always of great interest and concern. And this was another session where we really didn't anything on pit bulls that I remember, except cruelty. We had
there's something to deal with cruelty, and we'll get to that a little bit later.
Right. Concealed weapons. Actually, I think the legislation that came out this time kind of, in effect, simplified what the legislature had tried to do in previous sessions. And John, do you want to go ahead and cover a couple of these then?
AB 143. Now, the primary change in this one is it allows a person to qualify with one semi-automatic firearm and then get a permit to carry all the semi-automatic firearms that person owns. Previously, an individual would have to qualify for a permit with each semi-automatic weapon, and that would have to be listed individually. Now, it's like revolvers, and once you're qualified and are permitted to carry any of those that you own. This bill also clarified that the records regarding concealed weapons permit holders are indeed confidential. There was some argument about that based upon some litigation brought by the newspaper up in Reno against the former governor. AB 282 makes a few more changes again to concealed weapons. It requires that a background check be done not only on the initial application, but when a person applies to renew their application. It also contains the one permit for all semi-automatic weapons provision that was in the previous bill. And this bill also indicates that state parks, that you can have your concealed weapon in state parks, and that state park regulations cannot be more restrictive than or conflict with Nevada revised statute. So, evidently in the past there was an issue that the state parks had tighter rules on the use of or the carrying of concealed weapons and than statute did. Also, this one clarifies that the fee for a background check to get a concealed weapons permit can only be the cost of the check. It's not a money-making enterprise. And SB 126 is the third concealed weapons bill that we're going to talk about. And again, it dealt with the carrying of semi-automatic weapons, and it is the third bill of the session that clarified that a permit, once you have a permit for a semi-auto, you can carry all those that you own. You don't have to qualify individually with each. There was a bill, moving on here, that dealt with self-defense issues, not just the concealed weapon issues. Ben?
Yeah, John, I'm not sure. AB 321, it spells out that self-defense is viable if you're not the aggressor. You have a right to be where you are, and you're not committing any criminal activity or furthering criminal activity. I'm not certain that this really expands the need to not retreat or to retreat, but I think it codifies and makes it clear the standard that can be used with regard to the duty to retreat and self-defense situations.
And of note, on the last provision you're seeing in front of you on the slide, there was quite a debate, in particularly I think the Assembly Judiciary Committee, about how to keep people who perhaps were engaged in a drug deal, or one party shoots the other, from not trying to use the provisions of this bill to claim self-defense, and that's why the provision regarding the commission or furthering of committing of a crime or the furthering of criminal activity was included. The next section of our legislative review deals primarily with criminal legislation, or legislation impacting the criminal area of practice this year. And the first bill we're going to talk about is AB 373, and that bill deals with the destruction of property in foreclosure. And what came out this session, as we talked about with the foreclosure mess, for lack of a better term, is that sometimes persons who are being foreclosed upon would destroy the home that they were going to be moved out of, down to ripping the wire out of the wall, breaking the fixtures, clogging the plumbing, etc. So there was quite a debate in the legislature, and they came up with this bill that indicates that a person who conceals or destroys any property that is subject to foreclosure, and they have the intent to defraud or make the secured party suffer loss, is guilty of a misdemeanor.
Keep in mind as we go through these, especially this session, even more so than before, if there could be any fiscal impact attached to any of these, the chance of anything passing was very, very negligible. And that was the atmosphere that all the proponents dealt with. And some of the examples that people were doing with regard to homes that they were being moved out of, were horrendous, and actually the monetary damage was well beyond what a felony might be. But if it was going to have a fiscal impact on the prisons or the jail system, chances of it passing were just
fairly minimal.
Yeah, minimal.
We referred to this bill, Senate Bill 223, a few moments ago when talking about pit bulls, and this bill deals with cruelty to animals. It allows a person to make a confidential report of acts of animal cruelty to a peace officer, the Society for the Prevention of Cruelty to Animals, or an animal control officer, and that again can be made confidentially. This also stiffens up the penalties for persons who torture, maim, or unjustifiably kill an animal to a Category D felony. And this kind of gets into the area of domestic violence a little bit, because if that felony is committed, so the animal's injured, maimed, etc., in order to threaten another person, then that's ratcheted up to Category C felony. So there's two provisions there. And also this deals with dealers who have obviously puppies or sell puppies or kittens, and they cannot separate the baby animal from the mother before 8 weeks old, or the animal is consuming solid food.
John, I don't want anybody to think that I have a mad-on for pit bulls. I noticed that I think maybe there's a corgi in this slide, which may have some relevancy. You could put a golden lab in there too for me, but if you're a pit bull person, God bless you.
Okay, Senate Bill 282. This bill makes it specifically illegal to publicly display the Social Security number of another person willfully or intentionally. And that becomes a misdemeanor, and the person whose Social Security number was displayed then has a cause of civil action against the person who was doing the displaying. So again, that's another anti-identity theft provision that's been enacted in the statute.
John, I'll take AB 269, which deals with criminal procedure. There was an effort over the last several sessions to disclose to a grand jury if a matter had been heard at a preliminary hearing where, for whatever reason, the matter was not bound over to district court. And this bill, AB 269, mandates that a grand jury be notified by some statement that the matter was heard in justice court but not bound over. This is opposed by a number and supported by several, and the several won.
And this, of course, was, as many pieces of legislation are, a compromise piece. Initially, I think this bill indicated that if the Justice Court didn't find enough evidence to bind the person over, that the District Attorney's Office could not then seek the use of a grand jury. AB 142, this bill impacts several statutes, and in the review book, when looking at this section, you're going to see that there's hyperlinks and a listing of all the Nevada revised statutes that this bill amends, and if you click on that, it will take you to that specific statute. But this bill increases the monetary thresholds that determine whether theft or property offenses are misdemeanors, gross misdemeanors, or felonies. And generally, $250, what changed from a misdemeanor to a felony at $250, that number now becomes $650. And there's a couple obscure ones in there where $2,500 becomes $3,500 to switch it, I think, from a gross misdemeanor to a felony.
John, the other thing that comes to mind as we see this, with regard to the effective date of all of these pieces of legislation, again, some of them are effective upon passage and approval, some June 1, and a vast majority October 1. So again, you need to take a look to make sure that that you've got the effective date. I know John's been working with these. If you want to add something to that thought, John?
The effective dates are listed in the book, and amazingly enough, at a certain point, I don't remember all of them. This one will go into effect October 1st, along with some other ones we're going to talk about a little bit later.
Okay.
Okay, the next bill we're going to deal with is Senate Bill 257, and this bill found its genesis primarily in the vandalism that happened at the Red Rocks historic site down in southern Nevada, where someone painted graffiti all over historic Native American pictographs, etc. And so this bill ratchets up the penalty on that one to a Category C felony if you destroy or deface property that is of a historic site. Also, this bill in that situation allows the court to order restitution, and this also expands the authority of the court to order community service upon the third person being convicted of a third graffiti offense. They can be ordered up to 300 hours of community service over 1 year to clean up graffiti. Also, an offender who commits a graffiti type crime can be ordered to undergo counseling, and if the offender is a minor, the parents can be ordered to go to that counseling with the offender. Property owners whose property is damaged by graffiti can bring civil actions for 3 times the damage and 3 times the cost of repair and attorney's fees. So it sets that out a little more clearly.
Every time we got into graffiti discussion, an awful lot of people felt that this was dealing with young people, I mean children. But apparently the significant amount of damage with the graffiti are young people compared with old people, but are not juveniles and not children, so that they're adults, and therefore they should be responsible as adults.
The next bill is 376. And this bill increases the penalty for an existing violation. If a person interferes or denies access to a computer, a system, or network, that penalty is no longer that of a misdemeanor. It becomes a gross misdemeanor. AB 328, the next bill, and it's where we're going to start into traffic a little bit. This bill expands reckless driving to include being the proximate cause of death of a pedestrian or bicyclist when you're violating certain rules of the road, and you're going to see those listed out on that slide. Senate Bill 140, this is probably the big traffic bill that got the most attention this session, and this is the bill that creates a new misdemeanor offense to text, send or read data, or talk without a hands-free device on a cell phone while driving. Now, emergency responders, law enforcement are exempt. Also, reporting an emergency condition is exempt. The fine on this bill is enhanceable. The first offense would be $50, the second $100, and the third is $250, and that follows kind of the statutory idea of within those 3 offenses being committed within 7 years. Also, the first violation of this statute is a non-moving offense as far as the ticket, and the third, within 7 years, would result in a 6-month suspension of a person's driver's license.
Now, John, I'm sure you're going to give an analysis to all of the consequences of advising people of their rights and the consequences of pleading or being convicted of this offense. But what's interesting to me, in the last half a dozen sessions, any type of legislation like this would never possibly even gotten a hearing. But I suspect that what you're seeing is a change with regard to new legislators potentially effects of some of the term limit situation where we've got new people coming in that have a little bit different read on what home means Nevada is, and and you're probably going to see more of this sort of thing.
And I think that's probably a reasonable kind of statement, and just kind of an interesting side note. When this bill first came out, the fines were significantly higher. I believe the first offense was $250, a second offense was $500, and the third was $1,000. But as you can tell, before the bill was passed, those were brought down significantly.
And you're still not having seat belts as a primary offense.
That's true. The seat belts as a primary offense didn't pass, and also, as with a number of these, 3 offenses within 7 years bill, the legislation does not make any sort of provision for any entity being responsible for tracking the number of violations. AB 248 deals with bicycles, and this clarifies what a driver has to do when they come upon a bicycle while traveling. On a multi-lane road, they have to get into the immediate left lane if possible, and to pass a bike going the same direction. And if they can't do that, they have to pass a bike by a distance of no less than 3 feet between the vehicle and the bicycle. Senate Bill 323 is a fairly extensive motor vehicle insurance and registration measure. It does a number of things. The first one is it replaces the flat fee for a lapse of auto insurance, which was $250, with a tiered system. The system's a bit more complicated than we can show here in the slide, but it takes into account the length of time a person didn't have an insurance, if they've had an offense in this matter before, and various other things. The bill also makes some pretty substantive changes to registration. It reduces the period a person who moves to Nevada has from 60 days to 30 days to register their car here. It requires that that any car that is operated in the aggregate in Nevada for more than 30 days during any 1-year period has to be registered in the state of Nevada. It also spells out some more specific requirements as far as registering your vehicle in Nevada. If a person engages in a trade, a profession, or occupation, or is employed in the state, they have to register their vehicle here. If a person's children are in Nevada public schools, their vehicle has to be registered in this state. If a person of Nevada is operating a vehicle owned by someone who lives outside of Nevada, that vehicle being operated in the state has to be registered here. There are a few exceptions here. College students, one of them, active duty military personnel, and migrant farm workers.
You know, John, this is obviously a piece of legislation that raises more questions than it answers. And this is a good thought for me at this time, is that in your legislative website, you can pull up this bill, see the minutes of the hearing, and hopefully you can help understand a little bit better about what the legislative intent was in passing this legislation.
And with all these bills, as you look at the review manual and you're utilizing it as an electronic PDF file, if you click on the leading blue bill number, that'll take you to that site, and you can look up the legislative history, the votes that were taken on each bill, view the minutes, and all sorts of stuff for each bill. So you can kind of see the genesis of this one, where it came from, by reviewing that history.